Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi weekly community conference. Today is November 30th. As usual, I will get started first with the frequently asked questions, asking you if you folks have any follow ups, and then go on to the normal questions. I'm not going to have time today for new questions. I have a call scheduled later this afternoon. So we'll do the best with the time that we've got. That said, the first frequently asked question, what I marked as a frequently asked question, was from H-1B aspirant who says, when does one become H-1B cap exempt? That was the issue. And the government has a very confusing and I think unreasonable take on this. According to the USCIS, and they're not consistent in following this, but they've said to us that these are the rules operating on cap exemption. So first of all, unless you receive a change of status, if you're in the United States, you are not exempt from the quota. So the first principle is, if you are in the United States and you do not get a change of status, you are not exempt from the quota. The second principle is, if you're outside the USA and you don't get a visa stamp, you are not exempt from the quota. Now, in both these cases, whether you join the job or not is irrelevant. So the third principle is, whether you join the job or not is irrelevant. If you are in your home country, you must get a visa stamp. If you don't, you are not exempt from the quota. If you are in the USA, you must get a change of status, otherwise you're not exempt from the quota. Another principle number 4, is that if your approved H-1 is revoked before October 1st, then you are still subject to the quota. And the last principle is, if your H-1 is revoked for error or for fraud or misrepresentation, you are still subject to the quota. So these are the rules. And once again, I don't think I need to repeat them, but I will nevertheless. First, you must receive a change of status to be exempt from the quota. Second, if you're outside USA, you must get a visa stamp. Third, you don't have to join the employer after getting the visa stamp or change of status, but these things must be done. Fourth, your H-1 must not be revoked before October 1st. And fifth, your H-1 must not be revoked for fraud, misrepresentation, or erroneous approval. These are the basic rules. With that said, H-1B aspirant says, I have read, and also I did mention that the government is not consistent in following these principles. So if you're in doubt, go ahead and take a chance. Maximum they can say no, right? Then I'm reading from his question or her question. They had H-1 petition and H-1B visa was stamped, but they never traveled. So that's not a problem. And when a new employer applied for a cap exempt H-1B, they got it approved. Yeah, it goes by the principles I just told you about. In my case, I didn't use this H-1B visa. I didn't travel to USA. After my resignation, they revoked H-1B in November, which is after October. Good. But I got a denial. Oh, okay, so your H-1B was not approved. Of course, an overarching principle is your H-1 must be approved. If it is not approved, how can you be exempt from the H-1B cap, right? Yeah, no, there is no doubt about that. If you have not received an H-1B approval, and instead your case has been denied, you are definitely subject to the quota. Any follow-up questions on this, please press *5 on your phone. Any follow-up questions, press *5. Okay? So let's go to California. It seems like we have one follow-up question. There are two follow-up questions.
Rajiv,
Yeah, California, go ahead, please.
My follow-up is that if someone has worked on H-1B for a few years in the US, has I-140 approved, and leaves America for a few years, let's say 3 years or more than 1 year or whatever, uh, but after those 3 years wants to come back and work in the US, would that person be cap exempt?
In my opinion, yes. The only time this gets murky is if your H1 was approved more than 6 years ago. But I think even then, because of the I-140 being approved, you can very well claim that you're exempt from the H1. So let me give you a quick summary again of my answer. If the H1 was approved anytime within the last 6 years, no question, exempt from quota because of the I-140 approval. If more than 6 years ago, a little bit gray, a little bit more difficult to answer clearly, but certainly worth a try. Okay?
Okay, thank you.
Oh, you're welcome. Good luck. Okay, we have one more follow-up question. This is also from California. Oh, no, I think we are done with this. Okay, I may be mistaken. Did somebody else have their hand up? Yes, they did. Okay, here it is again. I thought I saw your hand up. Let's see. This one is, select this. And this one is from New
Hello,
Jersey.
Rajiv.
New Jersey, go ahead, please.
Yeah, can you hear me?
I can, yes, sir.
Okay, great. So I heard that, in this conversation you mentioned that if the original H1 is denied, so if you want to go to a new employer, then you have to be subject to cap. Is that right?
Yes, that is correct. Yes, sir.
Oh, okay. We cannot transfer the H1 that got denied in one employer, and can we not try our luck with another employer?
No, there is no question about. Oh no, you can try your luck, but you're subject to the quota.
No, but I have an approved 140, and I have a H1 which is well within 6 year limit.
Give me 1 second. Are you the person who posted this question?
No, not
Okay.
me. I just
Okay, I'm
had a
sorry.
follow-up because
I'm sorry because
Yeah.
this person, lady or gentleman who posted this is a little bit different. So your situation is different. In your case, you have an I-140 approved, and your H1 was approved sometime in the last 6 years. If your H1 gets denied, you can go to 10,000 other people, no problem.
Oh, okay. That's what I just wanted to, that really shocked me.
No.
for a moment,
Sorry,
yes.
sorry, because I thought you were the poster.
No. Sorry. Okay. Yeah. Thank you very much.
You're good.
Rajiv.
You're
And
good.
one follow-up question on the same topic. Like, so if there is a denial and if there is a transfer in progress, like for example, the H1 is applied and there is an RFE on that, and during that time, can I do a transfer as well?
Well, the
H1
government
transfer?
actually, if you look at the new regulations that came out in January 17th, they do talk about this situation. And basically, the idea is if you got 3 successive petitions pending, let's say original employer applied for an extension, first employer after that applied for a transfer, while the transfer was pending, another employer applied for a transfer. So you've got 3 H1s in play. The answer is it's a domino effect. If any case in between the one prior gets denied, then you won't get status in the USA. You'll have to go outside for visa stamping. That's the general rule. Okay.
Okay, but if there are only 2 employers, like one employer has applied for the extension and
Right.
it's in the RFE situation, and can I transfer it to an employer B only?
You can definitely try. But if the
So will there be a bridging?
if the original I-94 is over and the second case comes for decision, first case is either pending or denied, they'll make you go outside USA for visa stamping.
Okay. Okay.
Because the idea is that if you file beyond I-94, if you filed your second case beyond your I-94, then you are at the mercy of the first case.
Okay. So what if I file it before I-94 expiry?
Then there is no problem, because then you are covered by the I-94, the original I-94. Then even if the first case gets denied, you are still good.
Okay. So I can still stay here for till I get the approval from the second employer, right?
And you can work for 240 days after I-94 expiration, but you can stay here as long as the case is pending.
Okay. Oh, that's great. Thank you. And if there is a denial for any chance, how long is the grace period after I-94 expires?
After I-94, how long is the grace period? Well, it's interesting. I thought I knew everything about the law. One of my clients actually educated me, somebody like you. He said, I told him, I said, well, you know what, there is a grace period, but that's to leave the country. And he says, no, Rajiv, go look at the law again. I read the regulations, very interesting. Now what the regulations say is a little bit different than what they used to say earlier. And I didn't notice that small change. The new regulations say this, 10 days. If you are late in filing for your next H1 by, let's say, up to 10 days, and you have a very good reason, I think they use the language circumstances beyond your control, they will forgive you, or they have the right to forgive you for up to 10 days. On the other hand, if you get laid off or quit, and they use the term cessation of employment, you have 60 days grace period that you can ask for, as long as your I-94 is valid for up to 60 days. If your I-94 is valid only for 45 days, then the grace period is 45 days. So once again, there's a 10-day grace period and there's a 60-day grace period depending upon the circumstances.
Okay, in this 10-day grace period situation, so if there is an extension pending, and the I-94 expires in between, and this extension is still pending, and
I think
after that,
you can ask for those 10 days, but they are by no means certain to be given.
Oh, okay. And this 240 days that you were mentioning, what is that scenario? Sorry
I gotta go on. Look, that's up to, you should talk with your lawyers, but in a very brief one-line answer, whenever there is a timely filed H1B, extension or transfer, etc., you have at least 240 days to continue working. In a transfer situation, AC-21 may even allow you more time than that. So there is another area which is not quite clear, but 240 days is for sure. Okay, I gotta go on. Good luck.
Okay, yeah, thank you.
You're welcome. Okay, next frequently asked question. Guys, a bunch of people have just joined us. I want to repeat, I'm not going to have time for new questions, but I'll certainly deal with the questions that are here in front of us. Next frequently asked question is about EB1C international managers or executives green card. VS says, I entered USA in 2014 on L1A. Then I changed employer mid-2015 on H1. In 2017, again changed employer in a role equivalent to an international manager. Can my current employer file my green card under EB1? No. Not unless the EB1, because EB1C category depends upon the relationship between the companies, the one that you used to work for outside USA and the one that is applying for you inside the United States. So let's say let's take an example of IBM. There's IBM India, IBM South Africa, and IBM USA, and let's say they are all connected with each other through various ownership relationships. They are either subsidiaries of a common mother company, or they are affiliates. There are all kinds of definitions, but let's say they are related to each other. And you worked 1 year for outside USA for IBM South Africa, and then they transferred you here on L1A visa. and let's say 3 months later you joined Oracle, which has nothing to do with IBM, and you are an international manager with Oracle, can they file an EB1C for you? No. Even though your job is an international manager's job, your company Oracle is not connected with IBM South Africa, for whom you worked for 1 year outside USA. Star 5 if you have a follow-up question on this. Star 5. Okay, let's go on to the next frequently asked question. This is another frequently asked question I've dealt with quite a lot. So if I'm entitled to, let's say, 2 years of H1, because I'm in my 4th year, I applied for an extension and government gives me, let's say, 1 year extra. Now, if I clearly know that this is an error, can I use that extra 1 year? The answer is no. Many years ago, when this issue came up, USCIS said, look, if we make a mistake and you deliberately take advantage of it, we will consider you to be in violation of status. If on the other hand, there is error from everybody, that may be a more forgivable situation. But the short answer is you are not allowed to take advantage of USCIS errors. Just like I always give this example, if IRS sends you Trump's refund tax, we don't know what that refund is, but let's say it's $300 million and you want to go spend that, it's not going to work because it's a mistake and the government is going to ask you back for it. So don't spend that check. Same way, if USCIS gives you extension beyond what you're entitled, it is best to get that corrected. And it's government error, they should be able to correct it without any charge to you or your employer. Star 5 if you have a follow-up question. Okay. Let's go to, let's see, where is this question from? Oh, there's 2 follow-up questions. One is from Louisiana. Louisiana, go ahead, please. Hello.
Hello, sir. Hello, sir. Good afternoon, sir. This is Srikanth.
Yes,
is Srikanth. Good morning, sir.
Good morning.
Yeah, sir. I have one question. I am on H1B, and my 140 got approved.
Okay, hang on 1 second. Hang on 1 second. You've misunderstood the way we work. Unless your question is related to what I just discussed, I won't answer it. I'm sorry. Okay.
Okay, sir. No problem.
Yeah.
Thank you.
Mm-hmm. Okay. So sorry, guys. I have limited time, so I've got to make sure that we apply it appropriately. So let's go to California. California, go ahead. You have a follow-up question?
Hi, Rajiv. How are you?
I'm good, sir. How are you?
I'm doing good, thank you. So, am I in out of status or am I illegal?
Okay, let's review your case. I just gave the general principle. Let's see if I can give you an answer. You're completing 6 years on 14th Jan 2018. You have a visa stamped for previous employer. You changed jobs in 2017. They gave you an approval till 2019 by mistake. Okay. Now, are you sure you didn't have any time to recapture? Did you have some time to recapture and they gave you a recapture time?
Yes. It is until March, I think, of next year, 2018.
So no, my question is, were you outside USA a lot and they gave you recapture time?
No, not yet, basically, because when they filed for this extension, right? So they recaptured that amount as well. Whatever 2.5 months, I believe.
I think it's a good idea to get this corrected before you go. When are you planning to travel?
December.
In December.
Like end of December.
Yeah, and you have no way of extending it beyond Jan 2018?
No, actually, basically, I have 2.5 months basically after Jan.
Yeah, no, you definitely cannot use that. In my view, that would be a problem for you. Okay.
Okay.
So you wait until your
Okay.
I-140 is approved or your perm becomes 1 year mature. Only then you can get an extension of your H1. All right.
Okay. So I should not be going out. That's what you're saying.
You shouldn't be using that time at all, whether outside or
Okay.
inside USA.
Okay. If I go out and come before my visa gets expired, right? Visa stamp gets
I think
expired.
that's okay.
Is that fine?
I think that's okay. But the only problem is, I don't want you to use that approval notice because that document is erroneous. So even if you went out and came back showing that approval notice, it's questionable whether that's appropriate.
Okay.
Okay.
So am I out of status or
you will be out of status on 15th January or 14th January 2018, but not till then.
Okay. But even if I have 2.5 months out of US, then even that is not considered basically, right?
Oh, I'm sorry. You did you get an, well, whatever time you're genuinely entitled to, I think you are okay with that. So if you have till March, you're okay with that. But you should get the approval notice amended, okay?
Okay. Got it. Okay.
All right. Good luck to you, sir.
Okay. Any document that I need to carry if I go out?
Don't go out. Don't use that. Don't use that approval notice. That's my recommendation.
Thank you so much.
All right.
Okay. Thank you.
Bye-bye. Okay. Going back to the next frequently asked question. All right, we covered these. Okay, now this is another one that I kind of worry about this one, which is porting a green card to a self-owned company under AC-21 portability. So American Competitiveness in the 21st Century Act. This was, I think, a law passed in the year 2000. And 17 years later, we are still struggling with the basic issues. Although on January 17th, 2017, government did make it a little clearer. They said that it's okay to even port it to a company that you own yourself. So once your I-140 is approved, 485 has been pending 180 days, you can take a same or similar job and carry your green card over to the next employer, but the jobs have to be same or similar. Can you do it to your own company? And the answer is yes, but jobs have to be same or similar. There are two hidden problems here that you need to be aware of and be careful. One, it has to be an employer-employee relationship. Somebody should be able to fire you. That's very important. So if you are a 100% stockholder and you say, I'm an employee of this company, who is going to be able to fire you? Number two, your job should be same or similar. So let's say two examples I'll give you. Let's say you are a physician, a doctor, and you were working as a doctor in a practice. Now, if you have your own practice, then you're also the manager of the practice. You are the CEO of your corporation, probably. That's a change in the nature of the job. Similarly, if you are a techie, let's say you are a database developer or a database administrator, and you changed your job to your own company, you're also managing your company. So that becomes a different job, even though you're doing some DBA stuff. Therefore, there are two hidden problems. One, the employer-employee relationship, and the other is the nature of the job. Please be mindful of these two. Talk with a lawyer. Make sure that you've covered these two grounds very carefully. Star 5 if you have a follow-up question on this. Okay, there is one from Florida. Florida, go ahead, please.
Hello, Mr. Rajiv.
Hello,
I have one follow-up question. This is regarding filing the Supplement J forms. Does it have to be filed every time we change a form, or can we wait until the adjustment of status?
No, I think you should file it every time you change employers. There are a couple of reasons, and I'm speaking from memory. I've become very suspicious in my old age. I like to read the regulations again and again and again to make sure I'm telling you the truth. But I'm speaking from memory here. I could be off by a little bit. I think the regulations say if you want to take advantage of AC-21, you must file Supplement J. So there was some debate about this within the immigration lawyers community. Some people said that you can wait on the filing. I take it differently. In my view, you should file a Supplement J every time you move. Okay?
Okay.
Good luck, sir.
Thank you.
Okay, so we're done with this question. Let's move on to the next frequently asked question. There are some people who just logged in. I don't think I'm going to have time for a new for any new questions, folks, because we are kind of booked today. And I have a trial on Monday I'm preparing for, so I'm going to be very busy. Going back to, oh yeah, this is also an AC-21 question. The same idea, what is same or similar job? So what if I move from being a developer to an analyst? So he was an application developer, Oracle Financials. Well, first of all, I think Oracle Financials requires a lot of systems analysis, because Oracle Financials, as I understand it, I've never used it myself, but I know how it is done. Oracle Financials you can customize, and maybe you can do some system integration. So the term Oracle Financials developer automatically includes a lot of systems analysis, customization, etc. So if you go from being a developer to a functional analyst, I think a large percentage of the job is the same, right? So chances are that that's going to be okay. I think what you should do, because this is an important benefit for you, you should have your case evaluated by a lawyer. Show them the job description of the green card. Show them the job description of the next proposed job, salary, title, job requirements, and let them help you make a decision. To give you a general, abstract, non-exact answer, from what I see, I think it's possible to do this. But please have it reviewed just to make sure you're okay. One more thing I want to add. Remember that government now will give you a Supplement J ruling. So they have said that in the regulations also, that when you file a Supplement J, it's not going to be like the old times. Somewhere along the line, you'll get a ruling whether this job is same or similar. So if it is not, you can always go back to the old job or another job. That's the way I see the law. So I think you should be okay. So it's definitely worth exploring this in further detail. *5 if you have a follow-up question. *5. Okay. Let's go on to the next frequently asked question. Revocation of the H-4EAD rules. What's going to happen? Well, as you know, there is an appeal pending against a kick out of the case from the district court filed by some organization claiming to represent some US workers who have said that, well, having an H-4EAD law is beyond the government's power, and this should have gone through Congress, and this is hurting US workers. So the last thing that happened, I think a week or two ago, was the Trump administration asked for a little bit more time from the Court of Appeals, and the word on the street was that they are planning to revoke the H-4EAD regulations, although I have not seen anything official on this. And even if they want to revoke, it should take them a little bit of time, a few months at least, to revoke this. I don't know what's going to happen. I don't even know if Trump is going to last the term that the 4-year term that he's got. So this whole thing is very uncertain. I wish I could give you a better answer, but plan for contingencies. Plan for what am I going to do if the H-4EAD regulations go away. So I think It's a little premature for me to give you any definitive answers, but it's up in the air right now. Star 5, if you have a follow-up question, star 5. Okay, H-1B RFE for specialty occupation. Now this has become very complicated. The good news is that we got some approvals for level 1 programmers and programmer analysts, etc. And I think somebody else sent me on my LinkedIn account, somebody else had asked me this question, and I had told him it's very difficult to get approvals for positions like programmers, programmer analysts, systems analysts, QA engineer, especially at the level 1 level. But he got his approval. So that's the good news, is that if you have a case that can be presented appropriately, accurately, of course, there's a chance you might be able to win these cases. Now, you have received a specialty occupation RFE. There are some things that, like industry letter from other similar companies. Well, first of all, you do need to get your lawyers involved. This is not something you can handle on your own. Okay, so I'm not going to go into these because this is going to take me a long time to go over all the possibilities. One example of industry letter is, I'll give you an example. Some years ago, there was a question like this raised in the context of a law clerk. A law clerk. So a law clerk in legal industry is a law graduate. They're not a paralegal. They are still waiting their bar exam to be done with and the results to come typically. So I was approached by a law clerk who wanted to get an H-1B. So our firm gave a letter saying that we would not hire somebody who is not a graduate of a law school for the position of a law clerk. So something like that. So she was not working for us. She was working for some other firm, but she wanted support for her position that law clerks are law graduates. So that's what they're expecting here. And percentage of time spent on each duty, but please get a lawyer. I'm just giving you generic ideas. You approximate the percentages that on a typical day, I spend 30% of the time on system analysis, 20% on flow charting, 10% on actual coding, and 30% on system design. Whatever the percentages are, you just approximate them. Level of responsibility, what is expected here? I'm not sure what that means. That's not a technical term. But please get yourself a lawyer. Don't try to do it yourself. These are relatively complicated issues. Star 5 if you have a follow-up question. Star 5. And these RFEs have become quite common now. So, okay, let's see which one that is.
Yeah, hello, Rajuji.
Yeah, New Jersey. Go ahead, please. Go ahead, sir.
Yeah, I was the one who had filed those questions.
Right.
So basically, I am I'm under that software developers system software thing. Right? So the H1 extension was applied under that umbrella.
Okay.
And I also have a master's in computer applications degree there.
Right.
And also it's a Gates level 2 application.
Right.
So keeping all these things, like what exactly is this specialty occupation RFE? I read a lot about it in the online also. And generally what?
Basically, an H-1B requires the following. It requires a job that needs a degree, a bachelor's degree, and the degree must be in a specific subject. So if a job says require a college degree in any discipline, that job doesn't qualify as a specialty occupation. If a job says require a degree in computer science, computer applications, computer engineering, information systems, etc., that job would qualify because it's a narrow set of disciplines that are related to each other. If the same job says require a degree in computer science or world history, it won't qualify probably unless you were developing world history software. So in other words, the job must require a degree and a specific degree, and you must have that degree, that specific degree, or degree plus experience. Okay.
Yeah. Okay. But the experience will not count. Like I have 12 years experience in
No,
the
that
same
doesn't
field.
mean, because now the question is the job a specialty occupation? The question is not if you are qualified to do the job.
Mm-hmm. Okay.
See the distinction?
Okay. And one. Yeah. One other question on the industry letter. So can we show the postings from other job portals for a similar profile that they have asked for?
You can certainly do that. That is one part of your evidence. But these are complex issues. Like I said, even with the help of a lawyer, it's always uncertain whether you're going to win or not. Because what Trump has done is his administration, because they couldn't get Congress to pass any of the laws to change these things, they have become extremely difficult to deal with in every aspect of immigration law. After about 6 or 7 years, we are actually revising our legal fees because every H-1B now requires a 100-page response. It has become impossible to deal with this administration. But nevertheless, cases are still getting approved. I think most law firms like us, we pretty much have, if not 99%, high 90s rate of approval of all cases. So it's not like you're going to lose the case, but you can't take it lightly. Don't try to do it yourself. Just like I wouldn't, well, I probably would, but I shouldn't try to set up a database schema myself. I should let a professional do it. I shouldn't try to set up my DHCP myself. It is important to understand how, I know most of these things, but I shouldn't be doing it myself. In the same way, even though you can learn to do it, you will never be able to do it as well as a professional can. Okay?
No, my company would be working with the attorney. I just had this curiosity on these questions, so I was not able to contact the attorney directly.
You know what you should do? Go to the Administrative Appeals Office rulings. They are available online.
Okay.
Go to AO ruling. Just look at any of the last 5 years rulings. You will have more information than you need. They describe the law beautifully.
Oh, okay.
All right.
And is it a good idea to try a transfer right now, like H1 transfer? Try the luck with another employer?
We discussed that as long as either you are within the last I-94 period or you are willing to travel outside USA for visa stamping, you can of course try for as many cases as you like at the same time. Okay.
All right, Jimmy. Yeah.
Good luck.
Thank you so much.
Good luck. You're welcome.
Yeah. Thanks.
Okay. So I think that was the only follow-up question on this. Let's go on to the next frequently asked question. And this one is about a TN applying for a green card. I'm not sure I can answer all these questions. But typically what happens is TN does not allow you to have the intention to file a green card, at least not on the books. So if you are a TN visa holder or a TD visa holder and a green card is applied for you, you can have trouble re-entering the United States after the application or applying for extensions of TN within the USA. Okay. And what is the stage at which your green card intention is expressed? Not at the PERM filing stage. It is expressed at the I-140 stage. When you file the I-140, that's an immigrant visa. So you say, I'm on a TN visa, kids are on TD, visa is expiring 2019, PERM just got approved. I'm in the process of simultaneously activating my earlier H-1B. Good, because H-1B allows you to have a dual intent. My wife wants to stay on TN, kids on TD as long as possible, because employer doesn't want to sponsor H-1B. So, and due to H4EAD's uncertainty, it doesn't look like a smart option now to stay on H4EAD. So if I get my H1B, what will be the impact on my wife's future TN either now or in renewals? See, the problem is once her name is on the I-140, I think she has to say that somebody has applied for her green card. She should be looking at an H1. Otherwise, it's impossible for me to predict how it would work out. What is the risk if I travel with the kids overseas and enter the country? You can convert the children to H4. That is the easiest thing. If they are Canadian citizens, that can be done at the airport itself. It doesn't have to, based upon your H1 approval, they can convert the children to H4 right at the airport itself. What is the risk of myself traveling overseas? If you have an H1, there is no risk. You're fine. Let me not say no risk, but if everything else is okay, you have a project and everything else is all right, I don't think it should be a problem any more than if you had a visa stamping. So H1 allows you to have dual intent. What if she travels outside? See, the problem is, like I said, as a TN holder, if her name has been mentioned on an I-140, I tend to believe that she has exhibited immigrant intent. And the risk is the same whether she travels by herself or with children or with you. What is the safest option? I think H1 is the safest option for her. Star 5, if you have a follow-up question on this, please. Star 5. Okay. It looks like we are done with the frequently asked questions. And once again, I remind you folks, we won't have time for new questions. I just saw a couple of people log in. I can only answer the questions already posted today and the follow-ups on that. So now going to the regular questions, the non-frequently asked questions. This one is from Adhik. He says, person with H1B, H4 enters USA with a passport valid for 10 months, receives I-94. Which is good only till the passport validity. Yeah, that's normal. After 3 months of entering USA, transfers to another company and receives I-79 with I-94 attached, good for 3 years. Question, do I need to worry? No, because you got your 3 years now after you entered USA. So you are good for 3 years. And, if you're H1B, H4, both are good for 3 years, nothing to worry about. Star 5, if you have a follow-up question. Star 5. Okay. Let's go to the next question. Came to USA. Baldwin says, when I was 9 years old on H4 with my parents, I completed my elementary school, middle, high school, bachelor's, master's. Wow. Due to applying and reapplying for my parents' green card, I was aged out. So you changed to F1 visa, completed master's, got a position during college career fair, and started working with Company A with OPT. While working at Company A, consulting Company B applied for my H1 and got approved. Joined Company B. However, the project was getting delayed, so I didn't join the project location after joining. Company A filed H1 visa transfer. So B got your H1, but Company A that you used to work with wanted to file your H1 visa transfer. Okay. Once you got a receipt, you sent a resignation to Company B and rejoined Company A from October onwards. Company B told you that they got a site visit. Company A H1 transfer application received an RFE about level 1 question and pay stubs. So my questions are, since I did not work with Company B, I don't have any pay stubs. Is it legal to be on leave for 3 weeks? Well, it is legal. There is, if you need to be on leave for a specific reason, it's a difficult question to answer because there are many variables. Couple of weeks would have been beyond question. 3 weeks is a little pushing it. But can you be? Yeah, technically. Do you need to get a pay stub from the employer? I don't see why. If you were on leave, based upon your personal need of some kind. And Department of Labor has said need could be even something like a tourism break. I wanted to go to Niagara Falls, or I wanted to go to the Grand Canyon. So if you had some kind of a need, a reason, then I don't see why you should need a pay stub. If you didn't work, you were on unpaid leave of absence. Company B applied in level 1, it got approved. Company A, do they need to refile my H1 in level 2? That's a tough one. Because if they refile in level 2, you would be by that time out of status, right? So you'll have to go outside for visa stamping. I don't know, this is a tough call. If my H1 doesn't get approved, what are my options? Well, you've got one H1 approval and it's past October, so you're not subject to the quota. You can always step outside USA, have another company process your H1 and come back. If I get another job with higher pay, is that a good option? Sure. Only thing is you might have to go outside USA for visa stamping. Star 5, if you have a follow-up question on this. Star 5. See, the key issue here is that you are not subject to the quota anymore. So let's take your follow-up question. Georgia, go
Hi,
ahead,
Rajuji.
please. Yeah, Georgia, go ahead.
Hi, Rajuji. Thanks for taking my question. Here, I got the follow-up questions. Is it a good option to apply for a B1 to stay on the status and try for different company interviews and go with another company?
Original? Well, no, I don't think so, because you got a change of status from F1 to H1, and if you are out of status, then applying for B1 is out of the question. You won't get it within the United States.
Okay.
Yeah, I think your best option is, well, you could fight it out with employer A's RFE or go back and join employer B again. Well, not again, but join employer B, or get a third employer to file your H1 while you travel outside USA and wait for an approval.
Okay. So in between, till they reply back the RFE and get back a result, so can I continue working?
No. Continue working for employer B?
Yes.
See, I have my doubt whether you could have started working for employer B, because under AC21, you must be maintaining H1 status if you want to start working with the receipt. And I'm not sure you were maintaining status because you hadn't quite joined the employer yet. So, in my view, you shouldn't have kept working, and you should not keep working. That's the most conservative thing to do.
Okay, because as soon as I get the receipt notice, I started working after giving a resignation to company A.
That decision is questionable because I'm not sure you were maintaining status.
Oh, okay. Okay, so technically I'm out of status right now, right?
Unfortunately, that's the, like I said, that's the conservative view. Now, you could be aggressive about your interpretation and say, no, taking leave is genuine. I'm on genuine leave of absence, so I'm maintaining status. I wouldn't want to risk it. I would assume the worst and plan accordingly.
Okay. So if I join back to the college, is that a good idea? If I join back to the college?
No, because I think you're not going to be able to avoid stepping outside USA. That's my guess. You're going to have to step outside USA for a visa stamping. Unless employer A's case gets approved, that's the only choice left. Or you can join employer B back. I think that's okay.
Okay, because still he's not rejected or what you call withdrawn the H1, but he already got it.
Yeah, if they have not revoked the H1, I think that option also remains.
Okay, I can go back to company A even now.
I think so. No, company B.
Okay, because
the one who did your H1 in the first place.
Right, and so
So is it better I can stop working now, right?
Yeah, that's what I would recommend. Like I said, this is a gray area. You can be conservative in your interpretation or aggressive. I would rather be conservative and
Right.
say, okay, you know what, let's not have you continue working because I'm not sure you were maintaining status when you started working on the receipt.
Oh, okay. Okay, the best thing then, I can get some job right now and go back to my company, be employer who filed my first H1,
I
right?
think you
That
can.
will be a best
I
option.
certainly believe so. Yes, sir.
Okay, all right. Thank you very much. I appreciate that.
You're
Thank
welcome.
you.
Good luck. Okay, now the next question is, my H-1B completes on March 2018. Employer is submitting my I-140 this month end. I see. Questions regarding change from H-1B to H-4EAD. If my I-140 gets approved after March 2018, can I change from H-1B to H-4EAD and can I come back from? Oh, yeah. You can go from one to the other, but H-4EAD is possible only if your spouse's I-140 is approved, not if your I-140 is approved. If my I-140 gets approved before March 28, can I change from H-1B to H-4EAD? No, you can never change to H-4EAD based upon your I-140 approval. You can only do that if your spouse's I-140 is approved. There's no 180-day layover period in that. You don't have to wait. You do not. After my H-1B 6 years complete, can I move to H-4EAD? Yes, you can. Come back to H-1B anytime in the future? Of course, if you have an I-140 approved, anytime you can come back. My main intention is to change from H-1B to H-4EAD as soon as possible. You can always come back to H-1EAD. I'm lost with the series of questions you have, but let me lay out the principle of law for you. If somebody is on H-4EAD, somebody was on H-1, converted to H-4EAD, they can come back to H-1 anytime they want. No problem. *5 if you have a follow-up question. *5. Okay, let's see, where is this from? Virginia. Okay, Virginia, go ahead, please.
Hi, Rajiv ji. Yeah, so I would like to change to H-4EAD up on my husband's I-140 approval.
You can do that.
So not on my...
Right. Yeah, then there is no problem. And you can come back to H-1 anytime, no issue.
Okay, so my main intention is, so once my I-140 gets approved, so the next day immediately I can apply from H-1B to H-4EAD. Is that correct?
That is correct, if that's what you want, sure.
Okay, so I don't need to wait 6 months or 3 months after,
there is absolutely no such requirement.
Okay. Thank you so much. That you are always the biggest help for us. So thank you so much.
Absolutely my pleasure, guys. No need for thanks. Good luck.
Thank you.
Okay, let's go on to the next one. YP Zuniga says, I got married to a US citizen in 2011, got my conditional green card. I filed for I-751. It got denied. That's very rare. So you received an NTA. I think what you need to do, Mr. Zuniga, is that, or Ms. Zuniga, I guess, you should definitely get yourself a lawyer. And my knowledge of immigration courts is limited. My work is in federal courts. So from what I understand, most applications can be renewed before an immigration judge as well. So if you still have a good relationship, I'm not sure why this application was denied, but get yourself a lawyer who can represent you in removal proceedings, what used to be called deportation, and they should be able to have you renew your application before the immigration judge, as far as I know. *5 if you have a follow-up question on this. *5. Okay. Let's go on to the next question. So New Hope 13 says, are all employment-based green card applicants being interviewed? Yes, March onwards filings are getting interviewed. And some of the previous filings are also getting interviewed on random basis. Why is Nebraska so much lower than Texas? I have no idea. I don't know whether it's an efficiency issue or workload issue, but I really couldn't tell you. *5 if you have a follow-up question. *5. Okay. Anand Joshi says, I was formerly on F1 and currently on H1B. Always received a security background check while issuance or renewing my visa. Wife was on F2, then on F1 and has not received a check. She's currently in the USA with an approved 797 for H4. Does she risk a background check if she attempts to get H4 stamping from Toronto? I do not know the answer to that question, Mr. Joshi. But most of these checks are pretty quick in completion. The risk is always there. I can't predict what the risk is. But you said she's not received a security check request earlier. I'm not sure what you do. If you are working with technologies that can be weaponized, I don't know if you are, that could be one reason why you always get a background check. What they call Visa Donkey, Visa Mantis checks. So that could be if you have, what do they call it? Technical something, some of these technologies that can be used. Technology alert list, I think, TAL, yeah, technology alert list. So if your skills are on those, then government may want to do some further checks for you, but that does not get carried over to your dependents. So I'm not sure exactly what's going on. You can also ask for you can file a Freedom of Information Act request and get all information regarding yourself from the government and file with ICE, with DHS, with State Department, USCIS, just to get some sense of if there is anything negative on your record that you can try to remove. But so difficult for me to say in the abstract. *5 if you have a follow-up question. Okay. Question number 15. How long does it take to get a duplicate approval notice? These times they vary a lot. It used to be as little as 30 days. It has gone up to 8 or 9 months. So the times are available online. Double check that. You applied in June and you haven't heard anything. Yeah, my sense is it's taking between 7 and 9 months, but I could be wrong. In between, it dropped down to 4 months. These times keep going up and down. So check the latest times on USCIS website. *5 if you have a follow-up question. Okay. Let's see. Where is this from? This is from Canada. Okay. Yeah, Canada, go ahead, please. You have a follow-up question?
Hello, sir. Based on a receipt of the I-824, can I apply NVC straight up?
Can you apply, I'm sorry, what?
Based on the I-824 receipt, can I apply straight up to NVC to start processing, collecting all documents and everything?
My guess is no. But again, I haven't looked into this issue specifically. Many years ago, there used to be a procedure for attorney certified copies. So what we would do is, let's say we were doing your case through adjustment of status, and then we said, okay, you know what, he wants to go for consular processing. We used to certify your petition and send it to the consulate directly, saying that it's a certified copy, we applied for an I-824, here's the receipt of the 824. I don't think they're taking that anymore, but you can check with the consulate.
Okay. And generally, sir, this they don't show up. Used to showing the timeline, like a Texas Service Center is processing within 3 months, right. But nowadays they don't show anywhere timeline for I-824.
They haven't? Okay. How about calling the USCIS customer service? Maybe they have an answer for you.
Okay, sir. Thank you very much, sir.
Good luck. Okay. And then we've got number 16 from Andy. Sent a request for premium processing to TSC on a pending I-140. Oh my God, they lost that. UPS lost that. And then you sent a second one. Now they've taken money off of both the checks. Well, yeah, I think you can try contacting USCIS customer service and see if they can refund one of the fees. And if you don't get it, you can try claiming it from UPS. So you can contact UPS customer service and say, hey, give my money back. You guys caused me to lose this money because you messed up my package. *5 if you have a follow-up question. Okay. Next question. Isn't it a repeat of the old one? I came to USA when I was 6 years old on H4, completed my elementary, middle, high school. I think I just did this question. I will age out in May 28 and I've applied from H4 to F1. Oh no, this is a different case. I want to do a summer internship. What do I do? So let's see again. Due to applying and reapplying. No, I think it's the same person, but a different question. Applied for change of status H4 to F1. Case has been filed to Vermont Service Center. How do I do an internship? I don't think I can answer that question. Remember, if you have an unpaid internship, that's perfectly legal for you to do on any of these statuses. I don't see any problem with that. Is it legal for the employer to give you an unpaid internship? That's their lookout. They have to examine their internship programs and make sure they comply with Fair Labor Standards Act. But you can do an unpaid internship. Paid internship you won't be able to do, unfortunately. *5 if you have a follow-up question. *5. Okay. Let's see. This one is from New York. New York, go ahead, please. New York.
Hi, Rajiv ji. Thank you for taking my question.
My pleasure.
I wanted to ask the follow-up question that, since the H4 is going to expire on February 2018, and I'll be aging out in May 2018. So in this scenario, do you think that it is advisable to go get the visa from the consulate and abandon the change of status?
First thing you need to do is, you are still in school, right?
Yes.
Okay. First thing to do is to ask your International Students Office whether you can continue being in school because your F1 is pending. They've obviously issued you an I-20. So my sense of things is you should be able to continue going to school based upon the pending F1.
Okay.
Okay. Because F1 is one visa or status that's a little bit of an exception to the general rule that you can't start an activity until that visa is approved. So I believe that you can continue going to school. Just double check with your International Students Office. If your International Students Office says, no, you can't continue going to school until the F1 is approved, then obviously you have no choice but to go get a visa stamping done and forget about the change of status. But like I told you, I think you can continue going to school. Then what is the hurry? Let's just wait for the change of status.
The only concern is that I'll not be able to do the paid internship in the summer if it's delayed because of the processing.
In that case, you have to go for visa stamping. Okay.
Oh, okay.
Because there's there's no telling how long it will take. You can try expediting your case. Okay.
And how can I do that?
If you go to any of your search engines, I don't want to name any one particular one, whichever one is your choice. Go to an internet search engine and enter USCIS expedite criteria. It'll bring you to a page on the USCIS website that tells you, here are the 6 criteria for expedite, and this is how you do it. Typically, it involves making a phone call to the USCIS customer service.
Okay.
And you can say, look,
so will they be...
yeah, this is an important opportunity for me. If I don't have my F1, I will not be able to take this. Can you please help me and get the case expedited?
Oh, okay. Great. And also one thing, that since, my parent had applied for the green card, and it was denied, will that affect my case? Because I was just 10 years old.
No, not at all. No worries.
Not at all? Okay, great.
Okay.
Thank you.
Good luck.
Thank you so much, Rajiv. So it is better to wait for change of status than going to the consulate.
Well, because it's less uncertainty. When you go to the consulate, your parents are going to worry about you. You're going to worry about coming back in. So the thing is, most of these cases, in my experience, have been approved. We have other clients like you in this situation, and these cases have been approved without too much incident. So I think your change of status should be approved. USCIS so far was sympathetic to people like you who are aging out and going to school. So they were approving these cases. I'm not sure what's going to happen with you. Why add on another uncertainty by going for visa stamping?
Great. Thank you so much. That helped me a lot. Thank you, Rajivji.
Good luck.
Thank you. Take care. Bye.
Okay. So, let's see. Adil says, my company is getting ready to file for my AOS. Salary has increased by 50%. Oh, you poor man, you. I'm so sorry about that. Since 2009. So 2009 to 2017 is 8 years. In 8 years, 50% is not that much. Because I think you can argue that, and even prove it, that in the well, I'm hoping that you're in the IT industry. Typically in IT industry, when you get really good at your job, getting those kinds of raises, 5, 6, 7% a year, is not unheard of. Then, now this is different. You see, my job responsibilities are 75% the same. When the job responsibilities change, it becomes a much more difficult question to answer. So you've got to definitely deal with your lawyers and have them review whether or not it is the same job. I don't think I can answer that question in the abstract. *5 if you have a follow-up question. *5. Oh, they are calling me. I think I have run out of time. 1 second. Let me just deal with this 1 second. Yeah, Rajiv here. Art, I'm still finishing up my community conference. So I should be done in about maybe 7 or 8 minutes. Are you guys waiting on the conference call? Yeah, just tell them another 7 or 8 minutes. All right, bye. Okay, guys, I gotta go. Let's see. POM was approved. Yeah, so this one should be assessed by your lawyers. It's not something I want to make a guess on, because when the job responsibilities change, it should always be assessed by lawyers. Then the last question posted, or is there more? I thought Monica had a question. I guess she didn't post. Monica had sent me a question too, but she didn't post. I-485 Help says, we have an upcoming trip to India. I-90 is pending for name correction. Unable to get InfoPass appointment for I-551 stamping. Yeah, people have been traveling with that kind of evidence, but I don't know what to tell you. I think coming back, you could be put in secondary inspection. It may take 2-3 hours to get back in, but there's nothing in law that stops you from coming back in. It's a name change. You can certainly travel. You You got I-90 receipts, you got the original green card. Take a copy of the I-90 application also. I think you should be able to come in, but be prepared for a long wait. *5 if you have a follow-up question on this. Okay. I don't have Monica's email, so I really don't know what that question was all about. I don't remember. It was an L1 question. But folks, I've got to run. Thank you all for being here, and I'll see you again in 2 weeks. It's always lovely to talk with you guys. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.